Good morning, good afternoon to everyone joining us today for MCI's first webinar on maritime arbitration titled Maritime Arbitration Topical Issues. We are grateful to our moderator, Ms. Vasanthi, and our speakers, Duran, Madhvendra, and Philip, to join us for this webinar. International shipping industry is responsible for the carriage of all around 90% of world trade. Shipping is considered to be the lifeblood of the global economy. Trade by sea continues to expand, bringing benefits for consumers across the world through competitive freight costs. It is estimated that there are more than 50,000 merchant ships trading internationally, with a world fleet registered in almost over 150 countries. Despite its importance, like all industrial sectors, shipping can be susceptible to economic downturns. The contraction of trade following the credit crunch in late 2008 saw a dramatic and abrupt reduction in demand for shipping. It crippled the ship owners, and its effects were felt for years thereafter. The current scenario of COVID-19, though a health concern, but impacting global economy, may have even more severe repercussions than the 2008 downturn. However grim the economic situation might be, it often leads to more disputes, and the role of dispute lawyers, particularly arbitration counsels and arbitrators, seem to become more critical. Looking at the current situation, one could reasonably foresee a growing number of legal issues rising once the world returns to newfound normalcy. With this background, and the fact that India enacted the Admiralty, Jurisdiction and Settlement of Maritime Claims Act in 2017 to consolidate the laws relating to admiralty, jurisdiction, legal proceedings in connection with vessels, their arrest, detention, sale, and other connected matters, MCIA brings to you a webinar dedicated to this important subject, i.e. maritime arbitration. The panel today will deal with some of the important issues like what makes a good maritime arbitration, how has the current pandemic impacted the maritime industry, if at all, international aspects of maritime arbitration, use of technology, etc. Without much ado, let me kick this off by introducing our moderator and panelists, and then handing over the reins of this webinar to our moderator, Vasanthi, after which the participants could ask their questions using the Zoom app. Vasanthi. She is one of the first Asian women to join the ranks of the Admiralty and Commercial Bar in London in 1984, after obtaining distinction in her LLM from King's College London, and one of the youngest SILs to be appointed in 2001. Her practice covers a wide range of industry sectors and institutional rules, both as counsel and arbitrator. She regularly handles LMAA shipping arbitrations and is one of the current panel of Lloyd's salvage arbitrators. We welcome you, Vasanthi.
Thank you.
Duran. Duran is an arbitrator with over 40 years experience as an English qualified practitioner based in London and Moscow. His arbitration practice focuses on commodities in shipping, oil and gas, banking and finance, M&A. He has long experience of business-related legal problems in transaction economies. We welcome you, Duran. Madhvendra Singh. Madhvendra is an officer in Indian Navy, a chartered engineer, and also a fellow of the Chartered Institute of Arbitrators, CIR. He is instrumental in preparing the policy for dispute resolution in FIDIC contracts for Navy, and also undertook policy revision for ADR in the procurement manual of the government. He is an avid writer and has written extensively in the field of technology and blockchain and its use in dispute resolution. We welcome you, Madhvendra.
Thank you.
Last, but surely not the least, we have Philip Toh. Philip has been in legal practice in Singapore and Malaysia for over 30 years. He is the author of key practitioner texts such as Halesbury Laws of Malaysia on Equity, Conflict of Laws, and the various shipping titles. He is an arbitrator with the key maritime and international panels and is head of practice for shipping, international trade, and insurance with the Malaysian firm of Esme and Associates. We welcome you, Philip.
Thank you, Niti.
With this, I now hand it over to you, Vasanthi.
Thank you, Niti. And can I extend a warm welcome to all of you who are dialing in and to all of my panelists. Thank you. Today, we're going to be covering 4 broad topics. The first is what makes a good maritime arbitration? And we're going to be looking at perspectives from different jurisdictions. The second issue is to look at how this COVID-19 pandemic has impacted the maritime industry. And we're going to look at that from two angles. Firstly, particular types of disputes that are now being encountered, generated by the pandemic. And secondly, the challenges posed by remote hearings of arbitrations in the maritime sector. The third topic today is to look at technology impacting maritime disputes. And the fourth will consider some of the international aspects of maritime arbitration. Finally, we will have a Q&A session. So let me now turn to our first topic, what makes a good maritime arbitration? Can I ask Philip to kick off with his observations on this?
Thank you, Vasanthi. In my opinion, what makes for good arbitration, maritime arbitration, in terms of counsel and arbitrator, is appreciation of the operations of the dispute. Namely, how is a shipping dispute put forth before the tribunal? I want to illustrate case I did as counsel, not in arbitration, but in court. In arbitration and in trials, very often parties put forth the evidence through witness statements. So there was this shipping agent who made comments on 6 shipments. And in his witness statements, he put 6 different bills of lading. So it occurred to me to ask, can you look at this bill of lading, starting with the first one? Have you seen this document before? And to my surprise, he said, no. The second bill of lading, he said, no. You see, when parties appoint a maritime arbitrator, they look for somebody with experience in the industry, because hopefully they will get counsel who is also similarly experienced. So the nuances of evidence, and sometimes what is not put forth in the evidence, experienced maritime arbitrator can bring out the critical issues of dispute. And in this area, it's not just the hearing itself which is important. During the case management, an experienced arbitrator would be able to suggest to the parties, looking at the pleaded case, perhaps, what about this issue? So appreciation for the dispute, knowledge of the industry, so all these are critical and important issues, which makes for a good maritime arbitration.
Thank you. Mavendra, can I ask for your observations on that?
Yes, Vasanthi. First of all, good afternoon, everyone. And I want to really thank Mumbai Centre for International Arbitration for always being at the forefront of arbitration activities in India. You know, Philip has really covered the intricacies of conduct of maritime arbitration in particular. I would want to cover the jurisdictional issues of India, the maritime arbitration as it is in India. You know, over the last few years, India has really made monumental progress as far as the international commercial arbitration is concerned. Recent few amendments to the Arbitration and the Conciliation Act itself has tried to strengthen the 3 fundamental pillars of international arbitration, that is the cost, time, and the enforcement of foreign awards under the New York Convention. India as a jurisdiction really has a pretty evolved jurisdiction, I mean the Admiralty jurisdiction, because with the recent amendment to the Admiralty jurisdiction and settlement of Maritime Claims Act that was brought into force in April 2018, we have given the Admiralty rights to all the high courts of all the coastal states in India now. But the issue with the problem with the maritime arbitration in India is its jurisprudence, because I feel despite having a good admiralty jurisdiction, it's the maritime jurisprudence which has not really evolved with time. And I find that reason for that is basically the kind of the maritime ecosystem that we don't have, the absence of the maritime cluster in India, which is really not giving an opportunity for the practitioners to really have that kind of a caseload. So if we look at the World Bank rankings of 2019, they have ranked India at 163 on the indice of enforcing contractual obligations. That is how easy it is for a company to basically follow the regulations. And it takes around 1,445 days and about 39.5% of claim value for a dispute resolution in India. And if we look at, as far as the maritime industry is concerned, if we look at the Central Registry of Shipping in India, we would realize that during 1960s, we had a fleet of around 60 ships, and whereas in 2019, we have a fleet of around 1,400 plus ships. That's a significant increase. But what is the point to be noticed here is the number of people who are utilizing those ships that are flying the Indian flags, which was about 9% in 1960s, has reduced to 7.5% in 2019. That's because countries like China, Japan, and South Korea have created those flags of convenience, which India is lacking. That's why everybody is moving out of India and settling abroad. But now the government is conscious of this fact, and they're working on a perspective plan of 2030. And they're working on a 5-point agenda. First one being creating and improving the port and the shipping business itself. If we talk about the shipbuilding industry in India, you know that shipbuilding in India is 25% cheaper than anywhere in the world. And we have 27 major shipbuilders in India. And you see India has 150 plus organic ports. And if we compare semi-organic and inorganic ports like Singapore, Dubai, Colombo, and even Mauritius have really doing well as transshipment hubs. So maybe mainland India really cannot work well for a transshipment hub, but somewhere probably like Port Blair, which falls on the sea lines of communication, would be a good choice to first start with creating a good transshipment hub so that the maritime industry picks up. And even if we talk about taxations, we are charging about 30% of corporate tax on shipbuilding. I mean, if you see China, what they call it as an enterprise income tax, they reduced it to 0% when the shipbuilding industry was picking up and growing. I think we should look at even the amount of 5% GST that India is charging on selling ships to Indian customers. If you sell it to a foreign customer, there is no GST. And in fact, shipbuilders can also give kind of discounts on that, makes it much more profitable for them. For the Indian shipbuilders to sell it to India, really will have to look at doing something on that, because even the working capital loans are 7% here. And there are big differentials if we talk about bank guarantees, if we talk about insurance, reinsurance, and about their government has given some subsidies which were lifted in 2007. I think the first step would be to bring back our Indian companies to relocate in India, create a maritime cluster with charterers, ship owners, shipping lines, international financial brokers, P&I clubs, international law firms, and good consultants, and also development of like training and dispute resolution centers dedicated to maritime arbitration. All in all, to conclude this point, only one thing that I want to say is, taking a bit from Mahatma Gandhi, he said, best governance is no governance. I think we should allow some kind of autonomy and self-regulation in this sector for the industry to basically pick up. That's what
Thank you. Thank you. Doran, observations from you.
Yeah, I just very briefly want to chime in with Madhvendra, because having worked in Russia for so many years, I'm well aware that the Soviet Union had the largest maritime fleet in the world, much of which suddenly disappeared. But there is still a big Russian fleet, and there's still a Russian arbitration chamber for maritime disputes. And I don't know the answer to your problem, Madhvendra, but I'd certainly be happy to chat with you afterwards about things you might be able to do to learn from the Russian, take advantage of the Russian experience. What I would say about maritime arbitration is, going back to basic principles of arbitration, there are a lot of things that are good about arbitration. There are also a lot of ways in which arbitration does not meet its promises. It's supposed to be quick, cheap, and of very high quality. And it can be like that, and often is, I would say, in maritime arbitration, but very often it isn't. The reality of arbitration is that it's just as expensive as going to court, outside of India, certainly. It can take a long time, maybe not quite as bad as court in many places. And the quality is often very good with arbitration because you can choose your arbitrators. With maritime arbitration, you're often dealing with a much simpler situation, and a lot with arbitration depends on the cooperation of the parties. As Philip was saying, it's a matter of the expertise, but it's also the attitude of the parties. If they all want to have a big fight with each other and work every last point to death, then it will take a long time and it becomes very complicated. But if people work together and they adopt an informal situation and they try to solve the business problem, it can be much quicker. And with maritime arbitration, I'd say particularly the way it works under the LMAA, the London Maritime Arbitration Association, you very often get that because very often in the shipping world, people do business with each other and continue to do business with each other over a very long period of time. And if they're having a dispute, that's a dispute. They just need to solve it. And so they want to get on with it. And so the way the LMAA works arbitrations is they're ad hoc. It's not an institution. It doesn't tell you what to do. You run the arbitration. The parties run the arbitration the way they want to do it. It's often informal. They pride themselves on having a light touch approach, which means that their rules are relatively simple and straightforward. They have different sets of rules for small arbitrations, intermediate, and the mainstream large arbitrations. But they're all relatively simplified. They do have a lot of helpful guidance which pushes people towards making their case in a simple way. And many of their disputes, and this is generally true with the arbitration world, with the maritime arbitration world, are just documents only. So you don't have issues of witness and expert evidence that requires cross-examination. And that can often make it a lot simpler. I'm not saying that the LMAA is the only one. There are a lot of institutions that do arbitration. The LMAA does more disputes annually than all the rest of the main ones put together. You put together ICC, LCIA, and SIAC, for example, and LMAA does more because they have this very loyal group of people who come to them, and because they have a lot of arbitrators who are familiar with the industry. A lot of them are not lawyers, so somebody like Madhvendra is very much what they're looking for. Then many of them are ship captains and engineers and all kinds of people who have dealt with shipping, and so you get a lot of expertise. So that it's a different world from mainstream arbitration, and it actually works very well.
Yes, thank you, Doran. That also chimes with my experience. Most LMA arbitrations are in fact dealt with on documents only, which obviously keeps the costs down. LMA arbitration also benefits from having a large pool of very experienced arbitrators, and the law that is normally applied, because that is the law in the contract in question, is English law, which brings with it certainty and predictability. Can I now turn on to the impact the pandemic has had on the maritime industry? And perhaps I can turn first of all to Madhvendra to deal with the sorts of disputes that you are seeing being encountered in India following on from the pandemic.
Yes, so Vasanti, as far as this pandemic is concerned, as all of us are already talking about it, there are going to be numerous force majeure claims. But in the maritime industry, I think one significant amount of claims that's going to come is with respect to the crew. Now, Ministry of Home Affairs in India has come up with an order on 17th saying that the crew can be repatriated. But once they're repatriated from a foreign port, now who pays for that cost? And even if the crew that has been repatriated from that foreign port to India, there's a necessary quarantine for 14 days. And thereafter, the DG Shipping is going to issue the e-passes for them to travel to their home place. And now, around a lot of cases which I'm getting to know is going to be on the lay time and the demurrage charges. And also, one thing I wanted to mention was even the WHO has come up with an instruction guiding seafarers to basically go ahead and undertake this turnaround of their crew at foreign ports. I think which is a good step. But with respect to the demurrage charges, the cargo is not being discharged at ports because the bills of lading is not arriving, because the whole system is not working. Now, if you see at the standard P&I club forms, that has a provision for letters of indemnity. But we need to understand that letters of indemnity come with their own risks. What if tomorrow there's a third party who is in the possession of a bill of lading claims for damages? Then who is going to pay for the security of that? There's always a threat of arrest for that asset, for the carrier who has discharged the cargo with the authority of a letter of intent. Now, as far as the shipbuilding industry is concerned, we must understand that force majeure is only a contractual remedy, which is the subject of the language of that clause that has been agreed between the parties in the contract, written contract. And there are going to be certain non-contractual obligations that are not fulfilled and the claims for them. So that's where I think the parties would invoke the common law doctrine of frustration, which is embedded in our Contracts Act, I think section 56. But as far as shipbuilding contracts are concerned, the standard form contracts do have something called as permissible delays. And I think if I were to advise the shipbuilding industry, I think there are 4 points they must keep in mind. One is, although the standard forms have express FM clause, but the interpretation is going to be very narrow, only in reference to the language that has been used. The first thing that a shipbuilder must prove is that this event falls in the very language of that agreed contractual FM clause. The second thing is very important, is the strict evidencing against the current event, that only this current and the current event is responsible for that particular delay. Third thing is whether, as per the written contract, the shipbuilders have followed the contractual notification obligation of sending that or notifying the ship owner about the delay and the occurrence of this force majeure event and the cessation to claim any kind of permissible delays. And notwithstanding all this, if there is a further delays in the contracts, the ship owner still has a right to claim liquidated damages and even to cancel the contract. So I think the last point I want to make is that government can really help come in to help the parties and the shipbuilders in this by way of giving out orders that can be used as an evidence for causation to prove its claim of permissible delays. I think that's how the shipbuilders could actually do.
Yes. That's very helpful. Thank you. Philip, what about from the perspective of Singapore, Malaysia?
I handled a case recently where one of my clients was importing a cargo of coal. The vessel was arriving, and when the vessel arrived, the port shut down. So the coal could not be loaded. So when we look at shipping problems, which may go for maritime arbitration, one thinks about disruption. So you can just imagine here, the port was shut, but if you imagine the normal scenario, a lot of factories will be shut. So suddenly the charter parties are fixed earlier. So when ships arrive, there's no cargo to be collected, or only part of the cargo can be loaded, because not quite apart from shutdown of factories, we have disruption in the supply chain. The transporters may not be able to carry. And certainly in the case of maritime arbitration cases, the most common situation that goes for maritime arbitration are demurrage disputes. And if you can imagine, in a lay time situation, there will be evidential requirements by charterer and owner. And one of the requirements is the statement of facts. The statement of facts each party would have to have independent surveyors who take this statement. So if the charterer, who's not well advised and familiar, he may think, look, there's a shutdown. I don't have to engage surveyors, which means one party may be short of this evidential necessity. So later, when the matter goes for arbitration, you have this problem that one party cannot counter evidence. And the other problem in the pandemic situation is the normal operational issues are all disrupted. For example, if there's infection on board the ship owner cannot get free pratik. If they cannot get free pratik, the lay time chain doesn't even start. In fact, Madhvendra had raised an interesting issue on letters of indemnity and standard form provisions in some of the BIMCO contracts. I like to raise that in the very first reported decision of the Malaysian Admiralty Court, the case of Istana 6, which I argued, these issues were fully canvassed in a very good judgment by the Malaysian Admiralty Judge, Datuk Nalini, who's now in the federal court. So those participants who like a copy of the decision, do send me a request on LinkedIn. So coming back to the type of situations arising during this era, pandemic era, we are seeing the parties are seeing the problem. These problems have not come to fruition because they may be discussing amongst themselves how to resolve it. So later on, when it comes to disputes, to arbitration, then these evidential problems will all come in. The other aspect I like to raise, in fact, it is an obvious point, notwithstanding the problems of maritime arbitration, it is the only way parties can resolve a dispute if they are international parties. For instance, a judgment of the Indian court is not recognized in America, is not recognized in China. Similarly, if you have judgments against a Chinese party, it's not recognized. But under the New York Convention, we have mutual recognition of arbitration awards. So that's what I have to say, Vasant.
Thank you very much. Doran, can I ask you this? I've encountered disputes in the current climate for damages for detention arising out of the use of vessels as floating storage. Is that something which you're also seeing?
Floating storage is a very big thing now because very often it's the only way you can store oil. A lot of the facilities have reached tank tops, and so there's nowhere else to put the oil. And if there's nowhere to put the oil, you have to shut the field in, which is hugely damaging because you never get that money back. You ultimately produce the oil, but it comes at the end of the field life. So if you lose a day's production, that's it. You've lost it forever, and that's a lot of money in many cases. So what do? The traditional way of dealing with that is shipping. One of the earliest things I've ever dealt with was an offshore loading situation in the North Sea, where they were going to hook into a pipeline, but it was going to take a couple of years to build the pipeline. So they set up they bought 3 tankers, and they set them up with an offshore buoy. And my job was to organize the charters for the tankers so that they could. The big problem was that we had to be able to call it back from port part loaded, so it wouldn't fully discharge. And so this is the industry's traditional way of dealing with it. The problem is it's not so bad at this particular moment, but a month ago they thought they were going to run out of storage on the tankers, and the rates were going through the roof, absolutely going through the roof. You have to be very careful with your charter party when you're going into storage, because you need to make sure that you can actually do it. If you've got a time charter, you're probably going to be all right, as long as the vessel isn't issuing bills of lading that give people rights to the oil on board. If you've got a voyage charter, it's fraught with problems. You know, what are you going to do? Slow steaming? You've got to have a safe place for the ship to stay, and there are issues over fouling if the ship stays still for a long time. So there are all sorts of points that come along with that.
Yes.
And it's a hot topic. Yes, definitely.
I'm just going to chip in now with some observations on the technological issues that have been presented when carrying out hearings. And there have been various protocols that have been issued by LMAA, ICC, we've got the Seoul Protocol, but all of them recognize that because of the pandemic, a conventional hearing where everybody involved assembles in the one hearing room will not be possible, at least for the foreseeable future. And as a result, conventional hearings are rapidly being replaced by virtual hearings conducted by video links, such as the platform that we're using today on Zoom. The LMAA's experience and my own experience has been that Zoom is a very good platform and it's perfectly adequate to enable virtual hearings to take place in a satisfactory way. The Commercial Court in London is also carrying on business as usual using a remote platform, and arbitration applications and arbitration appeals continue to be heard. The Seoul Protocol on video conferencing is the particular protocol which is being recommended by the LMAA. One of the key issues that parties raise when a remote hearing on the merits is being contemplated is how effective can cross-examination of witnesses be? Will it be prejudiced by the inability to see the reaction of the witness or to test how credible that witness is? And I'd be interested to see what the views of my panelists are on that question, as well as any other challenges posed by remote hearings. Can I perhaps start with Philip on this?
I can foresee problems because in cases I've conducted as counsel, the physical cross-examination has, in fact, cross-examination is easily the single most important arsenal in counsel's armory. And the problem with online hearings can arise twofold: the arbitrator's perception of the witness, as well as counsel's ability to properly observe the witness. I'm not suggesting that because of online hearings, witnesses are going to be doing something untoward. It's just that it's difficult to perceive someone through a video, because there are cases which I've handled where the judges pick up the response of the witness and disbelieve the witness because the way he answers. So it's going to be more difficult for the arbitrator to perceive all these nuances and the overall cross-examination experience through video.
Thank you. Madhvendra, could I pass to you?
Yes, thank you, Vasanthi. So that's a very interesting topic for me. You know, I've been the ambassador for bringing in technology into arbitration, and I think it's a very doable thing. And first thing I want to put in the right perspective is calling it virtual hearing. I think when we call it virtual, it somewhere implies that it's some kind of a computer simulation. I think the right word to use is remote hearings, because we are ultimately people who are present there. Now, as far as, you know, international arbitration, there was a utopian dream of cost and time, which has actually now turned into a dystopian nightmare as far as, you know, our advocates are concerned and the way the whole thing is going. So let's talk about the protocols that, you know, 5 protocols that immediately came about when this pandemic happened, which really put things in the right perspective. One was the Seoul Protocol, the Delos checklist and the CIR guidance notes, ICC report on information technology, and ECAS protocol on cybersecurity. And I think LMA is also working with IDRC to come out with their own guidelines. So also, I don't know if we are aware of this International Arbitration Centre Alliance, where IDRC, the Maxwell Chambers of Singapore, and Arbitration Place of Toronto have come together to conduct the professional hearings internationally, because now I'll tell you, it's easy for the law firms to purchase all these costly, AI suites for the law firms and continue to do arbitrations from their premises. But it's not that easy for the arbitrators to purchase those kind of professional suites for conduct of arbitration. So this kind of alliance is really going to work very well when the arbitrators as well as counsel present in a particular jurisdiction can come to the premises of the center for the conduct of hearings. Now, the AI in arbitration is not about artificial intelligence. I call it adapt and innovate now, that is AI. There are three important aspects as far as the hearings go. One is opening statements. Second is the witness cross-examination, which Philip has nicely touched upon. And last one, not the least, is the closing arguments. But more or less, I think the opening and the closing submissions would still happen online, and opening statements and closing arguments can still be made. What remains to be seen is the witness cross-examination, where we used to see all these blazing guns trying to split the witness into pieces and show that they can really discredit the witness and make him unreliable. I think the art and science of advocacy is going through a change now. The science of what to do in a witness cross-examination still remains intact. But whereas the art at how to do it, I think needs a little bit of change, because we don't really need to discredit the witness. Let's focus on fact-finding. And I think if your counsel is really good, and the kind of technology of transcription, if you have right in front of you what witness has said all the way of your examination, I think it will help you to do that examination pretty well and actually coming to the point and finding the merits in that whole thing and actually come to the fact finding of it. Now, another thing very important for the present day scenario is that institutes which are holding these institutional arbitrations must immediately come out with their own guidelines for conduct to prevent any kind of a challenge on the grounds of due process. Because we know advocates, at the time when they have no arguments, they would use all kind of delay tactics, and they will use all kind of objections to jurisdiction, objections to even the existence of arbitration agreement, and they would go on and on for asking for all kind of interim measures. So I think it's very pertinent that all the institutes come out with the rules and regulations right now, and I think the technology is here forever, and it's better that we start to adopt it and learn how to use it rather than waiting to.
I agree with you. I agree with you. Doran, do you have any particular observations upon witness assessment if you're having a remote hearing?
Well, my view is more with Madhvendra than Philip, although I understand Philip's point of view, and it depends on the particular situation. But I've heard it from actually quite a few very senior arbitrators that you can actually see a person on screen in a way that you can't in a hearing room. And somebody once said, we'll get a bigger screen if you can't see them. But you can actually see in detail how they're reacting. Whereas in a hearing, you're a few meters away from them, maybe 2, maybe 5, depends on how things are set up. So I think there are two sides to that. I do rather agree. I think the system, the way people do a cross-examination will have to change. But I do think it will also still be possible to get a sense of the credibility of the witness, because that depends partly on the demeanor, and you can see demeanor on screen, but also, frankly, it's a matter of what they say. And in a lot of situations, certainly some of the court judgments that you read, the judge is saying, look, I believed Mr. So-and-so more than Mr. XY because he was just more credible. And it's not based on the demeanor, it's based on what they actually say. And I think when you challenge somebody's evidence, you're challenging them often on the basis of inconsistencies. So that's where I come out on that. The other thing I would say that Madhvendra hit on a probably the biggest topic on all these webinars that we're going through on remote arbitration, which is the question of whether the tribunal actually has jurisdiction, has the right to hold a remote hearing. And there is a point on the ICC rules that's problematic. It will be got over, I believe. But that's the first thing. And then the question is, if one of the parties objects, there's the first question, do they have the authority to start with? And then if one party objects, because they're trying to delay, and it seems that the only thing the tribunal can do is to listen to the reasons and come up with a view if the other side wants to go ahead. The problem then is, if both sides don't want to go ahead, but the tribunal wants to hold the hearing, what do you do?
I think it's a brave tribunal that goes ahead in those circumstances.
Yeah, yeah.
Shall we move on to our technology impacting maritime disputes, as we've become rather carried away in our previous discussion? So can I pass to Madhvendra, perhaps to look at blockchain in particular?
Yes, so see, maritime industry, I think, has always been at the forefront of digital transformation. So as far as the non-liner trade is concerned, where the charter party contracts and agreements are there, they're pretty safe because both the parties have fairly equal bargaining powers. But where I think the technology is really going to bring in a lot of benefits to is the liner trade, where the risks is more for the parties with unequal bargaining powers, especially with having the bills of lading. Now, some years back, the 5 big shipping companies came together to create a single digital platform for the electronic bills of lading. I'm sure we know of it. The concepts of Bolero and the S-Docs, Wave, CargoX, they wanted to basically create a platform for quick and authenticated exchange of bills of lading. And there is also, in 2007, United Nations also came with a convention use of electronic communication in international contracts, which was mainly with respect to the writing of the contract and the communications via emails and electronic platform, which gave it its much needed validity in international arbitrations. And recently also in December 2017, the UNCITRAL model law on electronic transferable records is basically come in support of the electronic bills of lading. Now, the problem that we were facing till now with the acceptance of electronic bills of lading was the authentication, because there was a central registry. I mean, the powers were held at a single place, but still the authentication was not very clear and the court still had an objection about it. But what's happening with the blockchain is, now if we see the bills of lading are actually the lifeblood of trade. And Merckx and IBM came together to create a platform which is now called as TradeLens. It is based on blockchain. The problem which was there with the electronic bills of lading of authentication has now been mitigated forever, because with the distributed ledgers, everybody, every stakeholder in that particular transaction is privy to the common truth. And the decentralized authentication has made it acceptable. Even the tribunals and the courts, the way the electronic bills of lading are being signed and being accepted all across the trade industry. Now, if we don't, I'm not sure if we know of this, something called as DCSA, that is Digital Container Shipping Association, which is trying to build a singular digital platform based on blockchain. We're migrating to the blockchain platform. And recently it was in news that the DP World has joined hands with the TradeLens to create a singular digital platform based on blockchain for the overall shipping industry. And also the Cochin port has now been integrated, the first port in India to have been migrated to the digital blockchain-based authentication system is the Cochin port. And we have used an API to integrate them. Basically, the whole idea of creating an integrated digital maritime world, I think, is really going to help the shippers all around the world, even the carriers and the shippers. I mean, equally, they're going to benefit out of this.
Yes. What I'm going to do is to pass on to our final topic, the international aspects of maritime arbitration. And then if any of the panelists want to chip in anything on the technological issues, they're very much at liberty to do so. Can I start off with Philip on this? You've obviously lectured extensively on international aspects. Tell us some of your perspectives from your practice areas.
Well, the international aspects of maritime arbitration derives from the transaction itself, because whenever you have shipping, it's a transaction between one state to another state and between two parties which are from different nationalities. For example, if you have a charter party, and this charter party is between a Malaysian party and a Japanese party, and if the charter party says English law to apply, when you consider the governing law, you're already going into private international law issues. Then sometimes when parties have the arbitration clause by choosing a forum, that's also a private international law issue. So the conflicts of law issue always comes in. And the earlier discussion that I had with Doran on the dichotomy between civil law and common law, that comes in because if you have a choice of arbitrators, sometimes the arbitrators are from a civil law background or common law background. I want to illustrate by giving an example of a case I did in 2012. This was a breakdown of a joint venture in Indonesia. So the governing law was Indonesian law. So the arbitration hearing was before a panel of 3. This panel of 3 were all common law lawyers. And the way I was counsel for the plantation owner, an Indonesian company. And interestingly, I came into the picture 30 days before the hearing because this Indonesian company did their work in Malaysia. What happened was 30 days before, I got a call. Philip, can you help us out in Singapore? I said, why? We have a hearing fixed, we can't change. And our Indonesian lawyer bailed out on us, suddenly became unavailable. So the evidence on Indonesian law was given by 2 Indonesian law professors. And interestingly, the facts were like this. My client wanted this other party, the investor, to continue to give capital. So after the first injection of capital, this other party stopped. And my client said, look, we don't need you anymore. In this respect, my client asked this party to come into their office 8 o'clock Friday evening, and he could not leave until 3 a.m. Sunday. So there was an issue of unconscionable conduct, and in respect of the evidence, Indonesian law had this principles of fairness and equity, which all Indonesian judges have to apply. And unfortunately, the panel, being common law lawyers, just dismissed the issue by saying, look, we are not judges, Indonesian judges, so it doesn't apply to us. So coming back to this issue, I think cultural appreciation of the governing law and the background of the parties is very important.
Can I just chip in here? We obviously see in maritime contracts provisions for a governing law and a dispute resolution mechanism. And I think one of the important things that we all have to bear in mind is how to protect the integrity of that dispute resolution mechanism where one of the parties decides to ignore it and, for example, commence court proceedings in jurisdiction that has not been agreed. The anti-suit injunction is something which has been developed by common law jurisdictions. I know that India uses it, England uses it, and it can be very effective in preventing disputes being litigated in a forum which hasn't been agreed or litigated in a manner when parties have actually agreed to arbitrate rather than litigate. Choice of law is very important when you are drafting your contracts. Obviously, we know that English law is the popular choice because of the benefits of certainty. We have a recognized system of precedent, which gives predictability of outcome. But there are other laws which parties may prefer because it may give perhaps better effect to their reasonable commercial expectations. One example that one might take into account is the approach of a jurisdiction to giving effect to good faith obligations. English law has traditionally been somewhat hostile to implying a term of general good faith in performance of contracts, whereas civil law countries are much more open to accepting that there has to be a general observation of good faith in performance of their contractual obligations. Can I pass to Madhvendra for his take on this particular issue?
Yeah, so talking about the future of maritime arbitration as such, basically I'm very mindful of the time. We really don't have much. So I just briefly want to touch upon the two aspects of it. One is about the procedural aspects wherein the low ticket arbitrations are concerned. I think we should have some shortened procedures like LMAA and SMA is doing. And also we have to, like as an industry as a whole, we have to create a singular digital platform where we can work on it. But recently I came across somebody had come for advice regarding now more and more parties are wanting to go to a settlement rather than going into long litigations and arbitrations in maritime disputes, because I'm sure that crunch of capital that they're having right now. So this particular institute is called as the International Forum for Settlement of Commercial Disputes. They are providing a technology-enabled platform for the parties to basically make an assessment in their dispute, whether to go ahead with a dispute resolution mechanism, a mediation or an arbitration, or just to settle that particular dispute with the other party. So I think that's a big advantage, at least for the low-ticket arbitrations. That is something which is doable. Second thing is, I am of a very strong view of precedence in maritime arbitration, because as of now, the awards are not being promulgated. I mean, the redacted awards could be published for this kind of a precedence to basically evolve and settle. So I would, by means of this, webinar, I would like to urge LMA also to basically start with, to have those redacted awards published, and basically kind of a creation of an international, for the uniform approach, basically. We're looking at a uniform approach beyond jurisdictions for the curial supervision, enforcement, and even the collateral assistance, based on international conventions, and remove all the fragmentations that come with individual countries, applying their own laws. So that is the possibility of having a standard understanding of maritime law across the world would really help us all in this industry.
Yeah, I think you've got a very valid point there, Madhvendra. And I think although there are summaries of certain of the LMAA awards which reflect points of principle which are anonymized, what we don't have is a general system of publication on an anonymized basis. And I know the ICC have recently introduced a system whereby, unless the parties positively object, there will be publication of their awards on an anonymized basis, so that there can be some precedent value. Doran, could I ask you to wrap up very quickly in a minute with your take on the international aspects of maritime arbitration?
Well, I would just say that you can, in a charter party or a bill of lading, you can have a governing law, but you have to remember that the overall law of the location will also apply. Now, if a ship is at sea, obviously there's no location, but if you're in port, you may have to have some regard. For example, if you're in a civil law country, the civil code may provide for force majeure, and there will inevitably be arguments over this, depending on how the situation arises, and parties will be saying, well, you're all very well relying on English law under the contract, but I've got a lot of other factors that need to be taken into account, and this will carry on. I'm sorry to say, I think there will be huge numbers of claims because so much business has been disrupted, and there will be a lot of pressure on people to settle, but there will also be a lot of pressure on people to dispute because they'll have very little alternative. And if someone's going bust and they can hold off the evil day by carrying on their action, they will do that. So that's where I'm coming from.
Well, thank you all for discussing the topics that I had put on the agenda. I'm now going to look at some of the questions which have been asked by the audience. And one of them is this, and perhaps I could ask Madhvendra and Philip and Doran to think about their answers to this. With the growing importance of Asia in the global economy, do you see India or Malaysia or Singapore becoming the hub of maritime arbitration rather than London? Can I start off with Madhvendra?
So that's a very interesting question. Like I've been covering, if you ask me, I think India is doing pretty well, and they have brought in monumental changes. The best thing about this jurisdiction, I feel, is that they're progressive. You see, every year we are coming up with new amendments and improvements. The recent, enactment of our Admiralty Act in 2018 has also seen a lot of changes. So there is an all-out effort from all the stakeholders in this jurisdiction to basically promote arbitration as a user-friendly dispute resolution mechanism. And even we see that recently the Supreme Court of India has been very, very progressive as far as the enforcement of foreign awards under the New York Convention is concerned, because the jurisprudence is more or less stable by Supreme Court not taking a non-interventionist approach of not really dealing with the merits of that case, and also giving a very narrow interpretation to the public policy as far as the enforcement is concerned. But I'm also conscious of the fact that Singapore, like SCMA, is doing pretty well. If we see after LMAA, who is at an average doing around 1,500 cases a year. I mean, with the World Bank report, I think Singapore is the second next, doing about like 400 cases on an average, whereas India does not even have an arbitral institution as of today. But with the growing maritime activity in a whole of Indian Ocean region, and the strategic location of India, and if India, we do some little bit of our homework and create a maritime cluster, build up a transshipment hub, I think we have a good promise to the world that this can actually become a good hub of maritime activity and maritime arbitration with time. But I'm not trying to discredit Malaysia. Of course, I'm sure Philip will have his own thing to say, but I am very confident with the kind of progress that we're making. We're sure to do well.
Philip, what do you reckon?
Well, if I could be so bold to comment, because I've spoken at 2 international arbitration conferences in India. I've also spoken at the Indian AIC joint conference. If I may be so bold to recommend, I think India, especially MCIA, is in a good position, because in India there are many arbitration centers, and it confuses the parties. So the way forward, in my opinion, is a center like MCIA, which it does have, concentrate on certain areas, make itself very strong in a certain area. My opinion is Mumbai is the center of shipping in India. Of course, they have other ports. So the way forward, example, SCMA, Singapore Chamber of Maritime Arbitration, of which I'm a member, concentrates on maritime arbitration. You have EMAC, Emirates Maritime Arbitration Center, and of course LMAA. So the way forward for India is to have centers to build up on particular areas. Coming back to Malaysia, we have one center, which is AIAC. And the way to go forward is to sell the center and sell the clause to your own companies. So Malaysian companies previously always chose arbitration center outside of Malaysia, or rather, they didn't choose. Once the counterparty suggests, they just agree. So, and this falls on the council in the countries to promote their own centers. I don't think the Asian centers would overtake established centers like LMAA, LCIA, ICC, but certainly the users of arbitration, the center and their council, as they grow in confidence in their own centers, and especially the pool of arbitrators, that's how these various centers will survive and thrive.
Doran.
I think it depends on whether you're talking about physical arbitration or remote arbitration. With remote arbitration, the physical location doesn't really matter. It's a matter of looking at who's got a good rule book that is going to suit your arbitration, where the seat is going to be, and that means the law governing effectively the arbitration agreement. if you're talking about physical location, then you need to look at, I remember reading a piece by the great Judge Michael Kerr many years ago, when he was still a judge, saying, and he retired actually, and he was doing arbitration, and he was saying that you need to look at the infrastructure available. Are there good hotels? Are there good restaurants? Is there support and backup, you know, in the way of secretaries, interpreters, etc., etc. So I think certain places will evolve. If you're talking about physical arbitration, you will need to have that sort of background. If you're talking about virtual or remote arbitration, then it really is going to be a question of the rule books and which ones are the most effective for conducting an international arbitration, because there won't be a location except in terms of the seat relating to the law applicable to the proceedings.
Yeah, if I could just add there, I think what will really determine the choice of parties in the future is the degree of support they can expect from the courts of the seat of the arbitration. And I think that India is certainly going in the right direction in terms of the pro-arbitration judgments which we have seen from the Supreme Court. And once I think the community as a whole can have confidence that that approach will be followed through, then I see no reason why India cannot quickly catch up in terms of its standing and popularity in the maritime community as a hub for maritime arbitration. I don't think there's any grounds for complacency on London's part in terms of it always being the automatic choice. There are a number of other very effective choices, and I think that increased competition will hopefully benefit the industry as a whole. As we are really over time, I'm going to run one more question, and please just limit it to 1 minute each if you would. What advice would you give to law students or fresh graduates who are interested in pursuing a career in maritime law and arbitration? So can I start, Movendra, with you, please?
Yeah, so I mean, for the young students who are passing out of their colleges and universities, if they really want to get into the practice of maritime arbitration, the first thing they should do is, by way of internships, associate with the shipping companies to learn the nuances of the industry first. Because maritime arbitration is very industry-specific field of arbitration, as Philip has also mentioned, and Doran has done that. Even in LMAA, most of the arbitrators who are appointed are from the industry. So for them to begin with, I think it would be a good idea to first learn the nuances of the industry, do some internships and associate with those kind of companies. And then they have to build their resume of having worked with maritime arbitrators, or as tribunal secretaries where the maritime arbitrations are happening. Would be a good way to learn before they start to practice as an arbitrator. I think that would be a good place to start.
Thank you. Philip, what would you suggest?
I would suggest that the young lawyer build him or herself up as a good litigator, because arbitration is disputes. And don't just think about shipping. You think about international law, conflicts of law, sales of goods, banking. So shipping, although it's technical, is also very wide. So have an insatiable appetite to improve yourself, to learn. And what you need to do really is to keep abreast. And it's a great time now, because you can learn from YouTube, you can learn from, if we go into a lot of the international firms, English firms, they've got a lot of good materials. You can learn online, but be a good litigator. I think you have, yes, certainly industry experience is important, but as lawyers, you pick up from every single case. And I'm still learning, and I believe all of us are, Vasanthi.
Doran.
Well, I would give any young person the advice that the most important thing is to make the most of your talents, whatever they are. And you have to succeed. There's that old saying, nothing succeeds like success. You have to be good at something and you have to get on with it. I would echo what Philip says about becoming a very good lawyer. If you look at the way things have worked, certainly in London at the bar, the top commercial chambers all have their roots in shipping. Why is that? Because there is so much shipping dispute work. I mean, shipping throws up probably more disputes than almost any other field. So it's a good field to get into, but you have to be very good at what you do, and you have to be successful. And success takes many, many forms. And there are plenty of arguments about, in order to be successful, you need to fail and learn a few hard lessons. Yep, that's true too. But you have to get on with it and get into it.
Yeah, I think a combination of the academic and the practical is what you need. In terms of the academic, if you have the opportunity to do a master's in shipping law or even a short course, which would give you all of the specialist legal knowledge in shipping, that is very desirable. In terms of practical experience, I went off and did the course that tells you how to plot courses of ships on charts, how to understand winds, how to understand currents, and how to understand a little about naval architecture. And I think when you actually start developing that practical interest, then the law starts to make a lot more sense and you build the two together. But I think trying to develop that specialism at an early stage will then set you on the right path for developing that as a career in the future. Can I thank all of my panelists for a really interesting session. I hope all the attendees have got something out of it. I appreciate we weren't able to answer all of your questions, but if you have got an email address through MCIA, I'm sure we'll try and answer them if you want to email us later. So I will part with you now and wish you a very nice weekend. Thank you, everybody.
Thank you, Vasanthi. Thank you, everyone.
Thank you.
MCIA.
Thank you.
Pleasure. Thank you, Niti, MCIA.
Bye-bye.
Bye.